paragraph 54 of the statement, you raised a question on whether this matter fell within IDAC's mandate. But then you go on to say that you considered a matter of this seriousness involving senior officers in the intelligence environment to be one that can be appropriately handled within the IDAC space. That's a bit confusing for me. What are you conveying? What are you saying in paragraph 54?
Yes. Comm'nr Baloyi, as seen on the other email with the Lushaba matter, I questioned whether this fell within the IDAC mandate. When one reads the docket right from the onset, you're seeing offenses, fraud, but then you go deeper into the merits. It doesn't. You don't have evidence. But that is why the first question is: does this really belong here? But if you were to follow these queries or find evidence of, let's say if they followed the queries, or even before I asked, they did an investigation and they found evidence of corruption, then I would have said, then that's where it comes up to say that if you look at the role and rank of the officers, maybe I don't expect the district and regional courts to can handle a matter of that nature. But the problem is there was no evidence to back it up, to say this case belongs here. The allegations are serious when you hear of them, but once you start reading the docket, you don't find evidence to back those allegations. So if there was evidence of reading of the applications and the unlawful appointment of a person who was going to occupy a position paying her over R1 million a year, and there was collusion with the police, definitely would have met the criteria of the IDAC. That is what I'm trying to say in the thing. But the problem is that there's no evidence. Even if one were to say we're transferring it to the lower courts were still going to see it with the same problem of, but where's the evidence to prove all these allegations?
Is another way, I'm just trying to understand what you were saying here, is another way of what you're saying in paragraph 54, that if the allegation of, because this case is about gratification, that's how they formulated it.
It's true.
Are you conveying in 54 that if we can make out a case for gratification considering that it involves these senior officials, the matter would fall within the mandate of the IDAC? Is that what you're saying?
That is the message I'm trying to convey, Commissioner Baloyi, that it would have been meeting this requirement of corruption involving high-level persons to a point that it then falls within the mandate of the IDAC.
Okay.
But it didn't come close to that. At least with the evidence, I would have expected right from the onset the person who read the docket or those, after compiling the evidence, once they said and presented, a decision ought to have been taken there and there to say, look, let's refer this matter to the lower court if there's evidence of prosecuting somebody with anything, because it doesn't also help to refer the matter to the lower court to say, deal with this problem for us. There's no evidence. See what if we can make a decision ourselves at IDAC to say there's a case or there's no case. If there's no case, we close it. We make our report. Why are we saying there's no case? And we file the documents. If there is a case, then we prosecute. But for me, there was no evidence backing up those allegations.
Now, Ms. Johnson was asked more than once whether the way things developed up to the point where these generals and brigadiers are arrested and then presented to court, and they're getting these ongoing postponements, whether no one in the office of the lawyers, an office which has many lawyers, whether no one ever raised concerns about the strength, whether this matter falls within IDAC's mandate, but two, the problems that we were discussing with her. You've discussed some of them with Commissioner Khumalo. What is gratification? Ms. Mugwele seems to have met the requirements. How do you have a charge of corruption and gratification when you say that she would have done something in the future, which is unknown. All of those were discussed with her. And then she was asked more than once, does this mean no one in your office ever raised concerns about this case, the merits of this case and the mandate of IDAC? And she firmly said, no, no one ever did. None of the lawyers. What do you say to that?
With respect to Advocate Johnson, I did. I raised, I think earlier we read one of my emails where I referred these queries to her. And it was not only that one email, but there's two, maybe even three others that I referred to her, where even with the Lushaba case. The Lushaba case is worse. That's why I'm saying. So I did. I don't know if maybe
she was not being truthful.
Maybe she did not have my email communications to her, but I did. I raised my.
Do you have reason to doubt? Do you have reason to doubt that she received your emails and your memos?
She received them.
She received
them. I can confirm, because once I send an email, Innocence, and there's one email, for example, where she responds to me when I'm asking her, should we serve at 28, or is this office, referring to her office, going to write a letter to the National Commissioner? I send it to Innocentia, but the ID then responds to me, say serve at 28. So, and when I send an email, and this is the practice in the office, to the PA, if you see that you're not getting a response, you make a follow-up with the PA. Did you give my email to the ID? Sometimes you go straight to the ID's office, or call, or send it.
So in short, she did become aware. She was made aware of concerns about this case, the Lushaba and the Mugwele matters.
She was. I did that personally.
And she was not truthful to us. If she did say to us, as I say she did, yes, that no one in the office raised concerns about this. She wasn't being truthful.
Commissioner, if that is what she said to this commission,
then she was not being truthful.
I don't agree with that.
Okay. She was not being truthful.
She was not being truthful. And I'm saying that with the utmost respect.
I appreciate, I understand that. Yes. Thank you.
Advocate Serunye, I want us to put away file 2, but before we do that, there is a standalone allegation that a young woman has been parachuted to the rank of brigadier. And I think Mr. O'Sullivan, when he was here, made that allegation, and it's one of the things he wants us to look at. So on 178 still, of file 2.
I have it, Commissioner.
My understanding of item 3.2 is that the moment you get a suitable person from outside and you appoint them as section head, technical support services, what then follows is that they will be given the rank of brigadier.
Yes.
So, and you get that rank because you are appointed to this position, not because you are 43 or 26 or 35,
yes,
or you are male or female. That does not matter. If you meet the minimum requirements, you go through the interviews and you are vetted and you get appointed to this role, you will be given that rank and you will become brigadier.
That is true, Commissioner. The advert was not referring to a specific race or gender or age. In fact, and I'm trying to look at this thing again, I think, if anything, it was trying to promote. I just want to see on the advert, I think it would have, if it's talking to promoting, okay, it's not there, but I think
it's in the national instruction.
It should be in the national instruction.
What you are looking at is in the national instruction.
It should be in the national instruction. I've seen it somewhere where, in fact, it's encouraging.
It's encouraging that you promote females.
That female persons be considered.
It's in the national instruction.
Indeed, Commissioner. But the fact that she was of a certain age, female, it's not amongst these.
The point is simply this: if you meet the requirements and you are appointed to the role, it cannot be a fraud or corruption that you are given this rank of brigadier. It follows as a matter of course, once you have been offered this job and you have accepted it, that you will be given the rank of brigadier.
Indeed, Commissioner. And maybe to add on, the fact that she was competing with experienced colonels and members of the police who have been in the same environment, doesn't mean if she performs better than them and she scored higher than them, then that means there's something wrong. We don't know what questions were asked, technical questions were asked, and she might have performed, or she performed. On paper, she performed better than them. Therefore, it doesn't...
Between you and me, and you would know because you are an advocate, there are 30-year-olds who sometimes perform better than me.
Indeed, Commissioner, indeed.
And I'm sure you've been in matters where somebody, a lot less experienced, less junior in terms of years, on the day performs better than you.
It depends. That's the nature of interviews, Commissioner. It's how prepared a person is for the interview. How much they prepare and how you perform. A person can freeze on the day and another one performs better. It doesn't mean we were supposed to take the candle because the advertisement was for both internal and external.
Can I just ask, and again, part of it is to understand what processes were followed here and how that accords with the law. You probably would have heard when Ms. Johnson was testifying, there was a debate at some point or a discussion with her about how Section 2813 was used and its purpose. And the concern being that it appears it was used, it was abused, it was misused, basically. Now, I'm looking here at your email of August 17. Now, we know that by August 17, the matter was already in court because these people, so it seems to me in the way that I've understood your processes, and you can correct me if I'm wrong. At this point, 17 August, your 2813 process happened, and then it was followed by your 28-1A decision to investigate. So you've done your 2813 and you go to 28-1, and then there's a J50, and then people are now presented to court. By all appearances, or from what you're explaining, by that stage we must have completed our investigations. That's why we are in court. And yet your email of August, your emails, in fact, let me say emails of August, they're still talking about investigating.
Yes.
And I'm looking at your page 53 in particular, the very last paragraph of that email of the 17th of August. Well, maybe before I do the last paragraph, you say that we should therefore not try to convince each other. Before the preceding paragraph, you say, once the alleged conduct committed does not meet the definitional elements of the offense, as I'm finding it to be in this case, that means no crime. In brackets, you say corruption has been committed. So we know that at the 17th of August, you held that view and you expressed it. And then in the last paragraph then, you say, having said the above, I'm still of the view that if we investigate further and dig more, we are going to find the evidence of corruption of the generals by Mokwele and not vice versa. Once our answer is in the bank statements, cell phone records, and computer data of the generals. There's no way that these people did not communicate prior to advertisement and during/after the interviews. If the generals gave Mokwele a job she did not deserve, it is for the particular reason, and we must find out this reason. Did she bribe them? And then you ask questions. You conclude what was the quid pro quo for the generals to act in the manner they did. Now, in this part, firstly, what I have a difficulty in terms of how you have understood your processes is you are past Section 2813 because there's been a decision.
True.
To investigate. You investigated, now you've charged. So you're now in the realm of court. And you, DDP, hold the view that as matters stand, we have nothing. And then in the last paragraph, you say, let's go search. And it seems to me that now what's going to happen with that last paragraph is to meet or satisfy a theory that has been formulated. We have nothing to work with, but our theory is these generals are corrupt. Let's go find something. And you can explain it. And if that's what's happening here, it seems to me that even on your own email, you are participating in an inverted process where what is the stage of things? You are in court. These people are appearing. Why are you saying we don't have a case, but I'm sure if we dig some more, we'll find something. That to me, on the face of it, is deeply problematic, but also your position, it's inconsistent with the position that you take earlier on, where you say we don't have a case, and then you say, but I'm sure if we search, we'll find something. That's not like a typical fishing process. Can you just explain how to make sense of your contradictory positions and what I suggest is a fishing expedition that you're suggesting should happen? And it's not simply a fishing expedition, it is in fact an abuse of your investigative / prosecutorial powers.
Thanks, Commissioner. Commissioner, I came into the matter after arrests have been made. These emails, especially that paragraph, I'm still raising questions. I'm still saying, but why are these people arrested? I'm saying to them, investigate. Dig some more is investigate, which I said shouldn't happen. We should investigate, finish our investigations. Once we satisfy that we have a good case, this is the prima facie case, then we go to court. In this case, it's vice versa. I'm coming in after the fact. I'm trying to rectify wrong things that have been done by saying, do your job, do what you ought to have done right from the onset. Looking for information is like investigate. I'm asking them, did you look into the cell phones? Did you look into the computers? Did you mirror image computers? So I'm playing that part which ought to have been done right from the beginning. And for me at the time, all this does not make sense. I'm still asking myself, how did this matter get to a point where it did? But do I have powers to say, there and there, we're cutting this off, or should I first satisfy myself that indeed there is no evidence, and then only then call it off? It's a pity we don't have some of the emails where I keep on saying, I'm going to write a report at the later stage to the ID, because I could see that this thing was started wrongly. So I'm not saying dig for something that is not there. I'm saying investigate. Digging for information is investigate. And if you find the quid pro quo, then that's your solution. That's your solution. But otherwise, there's no evidence of corruption here.
Let me ask you this. Was it, and I ask this, I'm not particularly familiar with the NPA Act,
yeah,
and the powers that it gives. Would you have had the authority, considering the Act, as DDPP? Would that, you may not have exercised the option if you had it, but is it one of the options that ordinarily are available or within your powers, where if you came in the way you did, you came in late, things had moved along, and you have formed the view that you express, where you say we don't have a case as matters stand, is it within your powers to say, let's stop and go back to the drawing board? I know you say people must go investigate, but I'm asking a bigger question, as in, you have people who are under bail conditions, who have been told they may not go to their offices anywhere in the country. You have people who are appearing in court, being postponed. So there's a disruption to some people's lives. Is it something within your powers that you could have come in and said, hold off, let's stop what we are doing, let's go back to basics and start from scratch, and we are not going to court, whatever we have in court, we're going to, I've heard of, it's not a withdrawal, it's something, removal from the roll, which is not a permanent withdrawal of a matter. Does that kind of power lie in your hands as something that you could have done here?
Yes, Commissioner, and that is why I was asking, we should remember this is maybe 9 days after I've become part of this is actually the second document that I'm writing to them to say, do the following. But like I earlier said to Advocate Bowie, if this had persisted up to a point, if I was still the prosecutor up to a point where the case, I would not have prosecuted this case. At some stage, I was going to call it off. Unfortunately enough, just a month after, I then got off the case. But I couldn't just on a week or 2 weeks after getting into the case and say, no, let's withdraw this. But it is after testing, what was the basis of starting this whole thing? And I realized there's no evidence. There was no basis for this. I should have done that maybe after consulting with the ID, sit down with her and say, look, this is the position, this is the evidence, I've read this, these are queries I raised, they are still unanswered, there's no evidence. At some point, I was going to get to that point. That's what maybe one is in management for, to raise these issues with the...
So Advocate Manilal, who succeeded you in this position and who has overseen this matter after you recused yourself, and on the assumption that up to when Ms. Johnson was testifying, Advocate Manilal was responsible for this matter as the DDPP. He has, what you're saying is he's got that power. He could at any point, after your many notes and his own observations, he actually does have the power to say, let's stop this. Even if it means, let's go and redo the work, but let's stop what we have put in motion. He has the statutory power to do that.
He does. That's like I have those powers. He does, but like I said earlier, I don't know at what stage he was appointed. And what I know is, with the evidence of the former ID 2 weeks ago, we got together, me and Manilal and Hlachwayo, and the two other prosecutors who were now part of this. And our decision was, based on what came out after the evidence of the ID, there's no way that this case can be saved or resuscitated. And we then asked for a meeting with one of the deputy directors, national deputy directors. We met with her and we said to her, we know now that the matters are seized with the NDPP, but this is our proposal. And forgot her name now. I think it's Advocate Bell. And I know that Manilal thereafter penned a memo to them based on those discussions with Advocate Bell, setting out our views. And then we were overtaken by events where I heard that the NDPP has decided that the case must be provisionally withdrawn. Yes.
Thank you. Thank you, Ms. Bott.
Are you saying there was an independent review by IDAC, separate from the one by Advocate Mutibi's team?
There was by the old and the new team in IDAC. We did need
the IDAC team,
separate the IDAC team. Yes,
okay.
That's correct,
Yeah. No, you don't have to go into the details. Yes. I just wanted to be clear that
there was a separate team,
processes.
My team and the team of Manilal. We met and we agreed that it appears we're looking at dead horse.
And in that kind of decision, at that point, what is the role of the DPP? It's the DPP, I think, from the evidence of Ms. Johnson. She submitted a charge sheet to the DPP. DPP says, I agree with the decision to prosecute. There was that kind of discussion. When you get to this point where you are now reviewing and you finally express the view that this is a dead case, and we know how it has played out, the DPP's role is what there? Do they participate in that discussion? And
Commissioner, the DPP did not participate in that discussion because the DPP is sitting at the provincial office, DPP's office. We are a separate IDAC. I'm not sure if our communication, the memo that was penned out by Advocate Manilal after our discussion, which was forwarded to NDPP, if the provincial DPP, Gauteng, has been copied, but the DPP was not part of these discussions.
Thank you.
The DPP's role would have, I believe, ended when they were doing consultation with the ID, and because the ID wants to prosecute in the DPP's space, there must be that consultation, and I believe it happened in this case, and the DPP would have agreed, but the role of the DPP ended there.
And on the question of now, we are reviewing and we are, if it is a withdrawal, forgive my use of the word withdrawal, I don't use it in its technical sense, but where the decision is made to remove the matter from court, you're saying the DPP, as far as you know, doesn't get to play a role in that. And I ask because from the evidence, once the ID, and you know this better than me, once the ID has made the decision to prosecute or to prefer the charges, that charge sheet was sent to the DPP, and the DPP wrote back and said, yes, I concur, or something to that effect. So that's why I'm asking about, now that you're changing course, does the DPP get to look at this and say, yes, I agree that we really are bad, or they just hear from the client being IDAC?
Yeah. In this case, we did not involve the DPP commissioner, because from what we gathered, the matter was now already in the office of the NDPP. That is why we wrote directly to the NDPP asking for a meeting with them, and we were then allocated Advocate Bell to meet with us.